Stop everything you are doing right now. A federal judge has just declared a major USCIS policy to be unlawful, and this decision has the potential to completely transform the green card process for hundreds of thousands of applicants throughout the United States. If you currently have a pending green card application, if you have been stuck waiting for years in the immigration backlog, or if you are planning to file for permanent residence in the near future, what you're about to hear could dramatically impact your timeline, your eligibility, and your entire immigration future. This is not guesswork. This is not hearsay. This is a binding federal court ruling that USCIS is now obligated to respond to, and the consequences are absolutely enormous. Welcome back to US Updates Hub. Today we are covering breaking news that is sending ripples throughout the entire immigration community. A federal judge has determined that a long-standing USCIS policy related to green card processing and eligibility is unlawful and must be revised. This stands as one of the most significant immigration court rulings we have witnessed in years, and it touches multiple categories of green card applicants, from family-based petitions to employment-based filings, and even certain humanitarian classifications. By the time this video concludes, you will have a thorough understanding of exactly which USCIS policy was struck down, the reasoning behind the judge's determination that it was unlawful, who stands to benefit from this decision, and who might face disadvantages, what steps USCIS is most likely to take in response, and most critically, what actions you should be taking right now if you have a green card application currently in the system. Before we get into the specifics of this landmark court ruling that could quite literally determine whether your green card application succeeds or fails, we need just a brief moment from you. Please go ahead and hit that like button right now. This is breaking immigration news that every single green card applicant needs to be aware of. And you're like assist the algorithm in pushing this vital information out to more people whose lives could be altered by this ruling. That one simple click from you could help someone discover new options that just became available to them. All right, let us get directly into what this federal judge decided and why the implications are so significant. The court case that just reached its conclusion involved a challenge to how USCIS has been interpreting and enforcing the public charge rule as it pertains to green card adjudications. For those who may not be familiar with the concept, the public charge rule is a provision embedded in immigration law that permits USCIS to reject green card applications from individuals who are deemed likely to become primarily reliant on government assistance programs. The underlying principle behind this rule, which has existed in one form or another for well over a century, is that the United States seeks immigrants who will sustain themselves financially and will not need to depend heavily on publicly funded assistance programs. However, what exactly qualifies someone as a public charge has been intensely contested and has shifted considerably over the years, depending on which administration holds power. During the previous administration, the public charge rule underwent a dramatic expansion to encompass consideration of many additional categories of public benefits and to place significant weight on factors such as income level, educational background, English language ability, and overall health status. That expanded version was eventually overturned by the courts. The subsequent administration then put in place a more limited version, but even that narrower version contained provisions that immigration rights advocates contended went further than what the underlying statute actually permits. The particular policy that this judge has now declared unlawful concerns the manner in which USCIS was applying public charge considerations to specific categories of green card applicants who should have been either fully exempt or evaluated under different criteria altogether. According to the court's determination, USCIS was improperly subjecting applicants in categories where Congress had specifically restricted or outright forbidden such scrutiny to public charge analysis. The judge concluded that USCIS had gone beyond its statutory authority by establishing requirements and assessment criteria that Congress never sanctioned. Let me explain what all of this translates to in real, practical terms. There are specific categories of green card applicants for whom public charge rules either have no application whatsoever or apply only in a very restricted manner. These categories include refugees and asylees who are adjusting their status to permanent residence, Certain special immigrant classifications, such as victims of human trafficking or violent crime, and some family-based categories in which the sponsoring relative satisfies particular criteria. The court determined that USCIS was nevertheless conducting public charge evaluations in these cases in ways that Congress never contemplated, effectively constructing obstacles to green card approval that should not legally exist. The judge's ruling was especially harsh in its assessment of USCIS conduct. The decision states that the agency overstepped its statutory authority, that it acted in a manner that was arbitrary and capricious, and that its policy stands in direct conflict with congressional intent as plainly expressed in the statute. These are powerful legal characterizations that essentially mean USCIS was fabricating rules that have no basis in the actual legislation enacted by Congress. The judge directed USCIS to immediately stop enforcing the unlawful portions of the policy and to reprocess any applications that were rejected or held up based on the improper application of public charge standards. So who stands to benefit from this ruling? First and most directly, it assists refugees and asylees who have been in the queue waiting to adjust their status and obtain their green cards. Many of these applicants were encountering extensive delays or outright rejections because USCIS was examining their financial circumstances, their utilization of public assistance programs, and their prospects for future financial independence. Even though the statute specifically restricts public charge analysis for this particular category. The court stated unambiguously that for refugees and asylees, USCIS may only reject a green card application on public charge grounds if the applicant is already primarily dependent on government cash assistance at the moment of filing. Projections about future likelihood are irrelevant for this classification. Second, the ruling benefits victims of crimes and human trafficking who are pursuing green cards through U visas, T visas, and VAWA self-petitions. These represent humanitarian classifications created to safeguard vulnerable individuals, and Congress specifically constrained how public charge determinations can be applied to them. Yet USCIS had been handling these applicants identically to standard family-based or employment-based applicants, demanding comprehensive financial documentation and rejecting cases based on anticipated future reliance on assistance programs. The judge determined that this methodology violates the statute. Third, the decision potentially assists certain family-based green card applicants, especially those whose sponsoring relatives are elderly, have disabilities, or possess limited income. The court found that USCIS was imposing documentation demands and enforcing standards that rendered it virtually impossible for some sponsors to satisfy the requirements even when they possessed alternative resources or household members who were willing and able to provide financial support. While the ruling does not remove the requirement for adequate financial sponsorship, it does mandate that USCIS apply the regulations as Congress actually drafted them, not as the agency would prefer them to read. Now, this does not mean that everyone receives automatic approval or that financial requirements vanish completely. For the majority of family-based and employment-based green card categories, applicants must still demonstrate that they will not become a public charge. Sponsors must still satisfy income thresholds through the I-864 Affidavit of Support. But what fundamentally changes is that USCIS can no longer pile on additional requirements or considerations that do not appear in the statute. They are required to adhere to what Congress actually enacted, not their own expanded interpretation that reaches beyond the law. What does this mean for applications currently in the pipeline? This is the question that is on everyone's mind. If your green card application is presently pending and you suspect it has been delayed, or if you have received requests for additional evidence rooted in public charge concerns, this ruling could be tremendously significant for your case. USCIS will now be compelled to reassess how they are processing cases in the affected classifications. Applications that were rejected based on the unlawful policy may need to be reopened and reevaluated. Cases that have been sitting motionless for extended periods due to public charge-related evidence requests may finally begin moving forward. However, and this is a crucial point, the transformation will not occur instantaneously. Federal agencies do not pivot direction immediately. USCIS will most likely require several weeks or potentially months to develop and distribute new internal guidance to its adjudicating officers, explaining how to implement this court decision. During that transitional window, there may be continued uncertainty and inconsistency in how individual cases are processed. Some USCIS officers might begin applying the corrected standards right away, while others might persist with the previous approach until they receive formal instructions to modify their procedures. What steps should you take if you have a green card application currently pending? First, establish whether your case falls within one of the affected categories. If you are adjusting status as a refugee or asylee, if you hold a U visa, T visa, or have a VAWA-based application, or if you are in certain family-based categories where your sponsor's income was marginal, or you were issued requests for evidence concerning public benefit usage. This ruling very likely pertains to your situation. Second, if your case has been languishing for an extended period with no progress, or if you received a denial grounded in public charge considerations, reach out to an immigration attorney without delay to explore whether this ruling furnishes grounds to reopen your case or submit a motion to reconsider. The court decision establishes new legal arguments that simply did not exist previously. Third, if USCIS sent you a request for evidence demanding extensive financial records, proof of private health insurance coverage, documentation of educational credentials and professional skills, or other materials related to self-sufficiency, speak with a qualified attorney about whether you are truly obligated to furnish all of that under the actual statutory language or whether USCIS was exceeding its authority. You may have the ability to respond to that evidence request more narrowly, supplying only what the law genuinely mandates. Fourth, maintain thorough documentation of everything. Preserve copies of all communications with USCIS, all requests for evidence, all denial notices, and all materials you have submitted. If your case needs to be reopened or reconsidered in light of this ruling, you will need a comprehensive record showing how USCIS handled your application under the previous now unlawful policy. Now let us examine what USCIS is most likely to do in reaction to this ruling. They have multiple available paths. They could accept the decision, update their policy guidance accordingly, and begin implementing the court's requirements without delay. This would represent the swiftest and most straightforward resolution. However, USCIS could alternatively choose to appeal the decision to a higher court, contending that the judge reached the wrong conclusion and that their policy was in fact lawful. If they pursue an appeal, the case could take years to reach final resolution. And throughout that entire period, there would be persistent uncertainty about which set of rules governs. USCIS could also attempt a middle approach, where they nominally comply with the ruling by publishing new guidance, but that new guidance still interprets the law in restrictive ways, just marginally less restrictive than before. Immigrant rights organizations would almost certainly challenge any such guidance if it still appears to exceed statutory authority, resulting in additional rounds of litigation. Given the current political environment and the general approach the administration has taken toward immigration policy, the expectation is that USCIS will probably accept this ruling and release revised guidance that makes a genuine effort to comply with what the court directed. They may contest certain narrow elements of the decision while accepting the fundamental holdings, but we will need to observe closely to see what actually transpires over the coming weeks and months. Let me walk through some specific circumstances and how this ruling might affect them. If you are a refugee who arrived in the United States years ago and have been reluctant to file for a green card because you have utilized food assistance, Medicaid, or other public benefit programs, this ruling makes it considerably safer for you to proceed with your application now, provided you are not currently primarily dependent on cash welfare assistance. USCIS is not permitted to reject your green card based on your use of non-cash benefits or based on conjecture about whether you might require assistance in the future. If you are a crime victim holding an approved U visa who has been postponing your green card application because your income is modest, or you have needed public assistance while recuperating from your victimization, this ruling establishes that those circumstances should not be weighed against you in the same fashion they would be for a standard immigrant applicant. You still must demonstrate that you satisfy the statutory requirements specific to your category, but USCIS cannot impose supplementary financial evaluations that are absent from the law. If you are sponsoring a family member for a green card and you are elderly or have a disability and are living primarily on Social Security income, and USCIS has been creating difficulties about whether your income is adequate, even though you have adult children or other household members who are prepared to serve as joint sponsors, this ruling may provide relief by requiring USCIS to accept joint sponsor arrangements more willingly, as Congress originally intended. Understanding what this ruling does not accomplish is equally essential. It does not abolish public charge considerations entirely for categories where they legitimately belong. If you are pursuing a family-based green card through a spouse, parent, or adult child sponsor, you still require a sufficient affidavit of support. If you are seeking an employment-based green card, you must still establish that you will not need public assistance. What changes is that USCIS is compelled to enforce the actual statutory requirements rather than inventing additional ones. This ruling also provides no assistance to individuals who are inadmissible on other grounds, such as criminal history, immigration violations, health-related issues, or fraud. It addresses specifically the public charge question. If your case involves complications unrelated to financial matters or public benefit utilization, this ruling will not resolve those particular issues. Let me also discuss the wider significance of this decision beyond individual cases. This ruling carries weight because it represents the judiciary pushing back against governmental overreach. Immigration law is established by Congress, not by USCIS or any other executive branch agency. When agencies exceed the boundaries of their authority and begin creating policy rather than executing policy, courts can and should intervene to correct that imbalance. This decision serves as a forceful reminder that USCIS does not possess boundless discretion to interpret immigration law in whatever manner they prefer. They are constrained by what Congress actually wrote into law. This could encourage additional challenges to other USCIS policies that arguably extend beyond statutory authority. There are numerous areas within immigration law where advocates maintain that USCIS has manufactured requirements that simply do not exist in the statute. This decision provides a blueprint for how to contest such policies and could generate further court cases aimed at curtailing agency overreach. For those watching this who are contemplating green card applications in the future, this ruling offers some valuable clarity about what lies ahead. You should still be prepared to establish financial self-sufficiency through the appropriate channels depending on your specific category, but you have the ability to push back with assistance from a qualified attorney if USCIS demands documentation or applies criteria that surpass what the statute actually requires. The law stands in your favor when government agencies exceed the limits of their authority. So let me ask you directly, do you have a green card application currently pending that has experienced delays due to public charge concerns? Were you denied based on financial factors even though you believed you met the qualifications? Do you fall within one of the categories that this ruling specifically safeguards? Share your circumstances in the comments section below. Your experience could help others recognize how this ruling might apply to their own cases. And every single comment gets read. If this video helped you grasp this major court decision and how it could impact your green card case, please hit that like button right now. This is breaking immigration news that has the power to alter outcomes for thousands of people. And your like helps ensure this information reaches everyone who needs to see it. And if you have not yet subscribed to US Updates Hub, please do so right away and activate the notification bell. Immigration law is in a constant state of evolution through court decisions, policy revisions, and regulatory modifications. We cover all the breaking developments and explain what they mean for real people navigating the immigration process. You cannot afford to miss updates that could directly influence your case. Thank you so much for watching this video. Immigration law is undeniably complex and bewildering, and court decisions of this magnitude can feel daunting to process. But this is genuinely positive news for many applicants who have been confronting improper obstacles in their path to obtaining green cards. Knowledge is your greatest asset in the immigration process. Understanding your rights, being aware of what USCIS can and cannot lawfully demand, and having the ability to challenge unlawful policies with the support of qualified legal professionals. These elements create real differences in outcomes. If you are dealing with a green card application affected by this ruling, you are strongly encouraged to seek guidance from an experienced immigration attorney who can evaluate your particular circumstances and recommend the most effective path forward. Many attorneys provide free or reduced cost initial consultations, and organizations such as the American Immigration Lawyers Association can assist you in locating qualified practitioners in your area. Stay informed, understand your rights, and never abandon your aspirations. This court decision stands as evidence that the system, though far from perfect, can still function to protect immigrants from unlawful government actions. Take care, and we will see you in the next video with more immigration updates from US Updates Hub.